Okay. Come on. So today and Monday, we're gonna cover some legal concepts or more legal concepts. Legal aspects of various supply management processes. So they're going to go through different types of laws that apply. The law of agency, and I think we've covered this a little before. Law governs the legal relationship between two parties, and one party being the corporation. The agent is authorized to perform or transact specific business activities for the other, the principal. So you are the agent as commodity manager, and PECAR is the principal. So corporations are legal entities. They cannot act for themselves, though. They have to act through agents, which is you guys. In general, the agent is authorized to act under the control and for the benefit of the principal or the corporation in dealing with third parties, which would be suppliers. The agent functions as an intermediary between PECAR and the suppliers to form a contract. But the contract is between PECAR and the suppliers, not you and the supplier. Agency is consensual relationship, meaning that the principal and the agent must both agree to it. And remember, you all volunteered for this job. So here's the agency relationship. Here's the agent, that's you guys. Here's the principal, which is PECAR. And here's the third party, which is the supplier. So the contract is between these two. And then the contract is negotiated between these two. And then this has got the agency relationship here. So definition of an agent, a person or organization authorized to act for another person or organization, the principal, in prescribed dealing with a third party. So all purchasers and most salespeople are agents with varying levels of authorization. So the principal is bound by the commitments of the agent. So if you guys go around signing a bunch of contracts, we'll get into this in a minute, you're binding PECAR. So general versus special agents. So the general agent is one who's involved in ongoing activities or a series of transactions. This is usually the buyer. The special agent typically authorized for a single transaction. So that's the salesperson. They're authorized to develop business for the corporation. They're not usually authorized to sign contracts or commit their organization to a contract. A principal is not generally liable for acts of a special agent that are outside their actual authority. And salespeople are considered special agents while purchasing are considered general agents. So the purchasing generally has more responsibility and scope than a special agent or a salesperson. Fiduciary duty. An agency relationship is a fiduciary duty, obligating the agent to act in the interest and for the benefit of the principal. So duties of the agent. Loyalty, must act in the interest of the beneficiary and solely for the benefit of the principal. So avoid conflicts of interest, and you can't act as an adverse party without the principal's consent. Which they would never give, so you can't do it. Accountability. The agent must account for all money and property received from and paid out for the principal. This is kind of like your expense account. Obedience. Oh, you're going to love that one. The principal is in control. And if that isn't clear to you, it should be now. It is the principal's business at hand, not the agent. So you are doing business for PECAR. And diligence. The law requires the agent to perform with reasonable care and skill. So principal's duty. Several requirements. So compensation, they got to pay the agent. So compensation can be conditional on successful completion of a task. This is called incentive compensation or commission. Reimbursement and indemnification. So the principal must reimburse the agent for any expense incurred in carrying out your duties, this is your expense filing. And if any claims are made against the agent arising out of the agency relationship, the principal must cover those claims. So the supplier cannot sue you. The supplier can sue PACCAR. So maintenance of accounts. Like the agent, the principal has a duty to keep proper accounts related to the agency relationship. So PACCAR has to do withholding taxes. And the principal must provide the agent with an opportunity to serve. So the agent must be permitted to perform the service called for by the agency without interference from the principal. This doesn't mean that you get to sign contracts, because our policy at PACCAR says only the VP can do that. Well, the VP and the executive director. This doesn't mean you can do it your way either. So if you go back here on point 1C, obedience. All right, limits of authority. In U.S. law, for agent's actions to be binding on the principal, the agent must act within the scope of the authority granted by the principal. And this is found in our signature matrices we were looking at, and policies or procedures. Actual versus apparent authority. So actual authority is the specific authority given to an agent by a principal. Maybe express or implied, but it is always based on the principal's communication to the agent and unrelated to any third-party perceptions. So you have two different types of authority. You've got express authority, which is specifically spelled out by your job description. And you've got implied authority, when the principal is less than comprehensive. The law implies whatever is necessary to accomplish the principal's expressed intent. That's implied authority. And then there's apparent authority. So a type of authority created in an agency relationship when a principal permits an individual to operate in a fashion that allows third parties to believe that the individual is an authorized agent. So if engineering leads the supplier to believe that they can grant the supplier the business, that's apparent authority, because engineering does not, by our corporate policies, does not have the authority to do that. It represents an unauthorized purchasing through bypassing the supply management function by other organizations. Also known as rogue or maverick buying. Engineering just goes and does whatever they want with whoever they want. The principal must communicate to the third party that the conduct is unauthorized and they will not be bound by it. So this is where you come in. Once you found out that engineering has racked up a bunch of test time with the supplier, and then they want you to go do an RFP. It's like, well, just do it to the one guy. It's like, well, now you got to go talk to the supplier and say, hey, the engineer is not authorized to source this stuff. Sorry. But if you bid really low, we'll give it to you. Ratifications. After the fact approval by the principal of an otherwise unauthorized action taken by an agent. So if engineering, for instance, signs an LTA, the action is not authorized by PACCAR policy, but it could be legal if the agent would have had authority. This not so much. Engineering never has the authority. So if a commodity manager actually signed an LTA instead of the VP, that could be misconstrued as apparent authority. The principal must have existed when the agent acted. The action must have taken. Specific principle is ratifying the action. So if you ratify the action, so if you went out and signed an LTA and supplier was shipping at that price, and if PACCAR accepted the parts and used them in the truck, then they're ratifying that contract. You're probably still in trouble, but the supplier is going to get paid and the contract is in place because the principal ratified it. So ratification differs from apparent authority, and ratification occurs after the fact. So PACCAR says, yeah, that's okay with that LTA. He shouldn't have signed it. Should have been the VP, but we'll accept it. Some circumstances, a principal may imply the ratification of actions of an agent by retaining the benefits. So if they receive the parts from the supplier and put them on the truck and sell the truck, That's ratification. Oops. So role of legal counsel. These are our folks up on the 11th floor. And we use these guys for different things. They do POTs and Cs, domestic laws. We've got a standard RFP template that they've already approved, but if you do something different, especially if it's got something to do with indemnity or something like that, then you should always run it through legal. Warranty disclaimers, you should always run your warranties through legal unless there's absolutely no changes to the template, along with your LTA, same deal. No changes to the template, it's fine. Otherwise, run it through legal. Liability caps are another problem, especially in a warranty. And financially troubled or bankrupt suppliers, yeah, you shouldn't be doing new business with those guys. Bid performance bonds, we don't do those. Supplier acknowledgements, we don't use those either. Supplier alliance agreements, these are LTAs with Cummings and Eaton and those kind of guys. Delegation of authority given to buyers to commit their company's company based on dollar value. This is our signature matrix that we looked at. If the amount's greater than that stated, requiring additional authorization. So although you're allowed by PACCAR to negotiate the LTA, you can't sign it. Types of laws, very rarely laws will be the same worldwide, and they aren't. And one of the reasons is in the United States and Canada, we use something called common law, also known as precedent law or case law. It's developed by judges and courts on decisions that have come prior. That's called case law. What Europe uses is called civil code or Roman law. And most of the rest of the world relies on explicit codes of behavior established by the governing authority. They've got a lot of statutes, and precedent isn't as important there. So the two laws are very different. Agency purpose is to allow one party the principal to accomplish an objective. It's a consensual relationship, yada yada. Contract and commercial law legally binds the principal to the third party. UCC has got a lot of contract stuff in it. Sale of goods of $500 or more must be documented in writing. You shouldn't do that orally. Other countries' laws are different, and you got to know what they are. With regards to performance, many jurisdictions show strong deference to the intentions of the parties as reflected in the written document. So if you're doing business outside of US or Canada, you really have to pay attention when you're signing contracts and run it through legal. Contracting parties may determine which country's laws will apply to their contract by choice of law. You can also do this by state too, and you run into this a lot where venue is a thing that gets batted back and forth. Commercial law refers to a variety of laws applicable to rights and relations to parties engaged in commerce. And this is where the Uniform Commercial Code comes in. It's not a body of law. It has to be adopted by each state. And there's some version of the UCC code in each state. Electronic commerce refers to business that is conducted over the internet. Usually these laws do not change the underlying law. For example, just because you do it electronically does not change contract law. And then there's antitrust, and you guys get to do this little study thing on like every 2 years or so. Instead of focusing directly on a relationship between contracting parties like commercial law, this body of law is concerned with the impact that relationships might have on business or the market. Does it eliminate competition and go to a monopoly? It's aimed at anti-competitive behavior. It's been around since some version of these laws have been around since 1890. Usually addresses concerns such as price fixing, boycotts, exclusive dealing arrangements, and deceptive trade practices. When contracting across international borders, a choice as to which country's antitrust laws will apply. And the U.S. antitrust laws reflect a fundamental commitment to free enterprise. It's the responsibility of every company to compete in accordance with these rules or fair rules. So you got a few U.S. antitrust acts. The Sherman Antitrust Act from 1890 is the first one that came up, and it has to do with price fixing, reciprocal buying, and group boycotts. And you've got the Clayton Act of 1914, prohibits things like exclusive dealing. You'll only sell to one customer or only buy from one supplier if you buy my trucks, kind of thing. Companies must notify the FTC and DOJ before consummating significant mergers or acquisitions. And this is where you see them, the FTC and the Department of Justice will refuse a merger because it reduces competition in the industry too much. The FTC was created in 1914 to prohibit deceptive and unfair trade practices. And the last one that was significant was the Robinson-Patman Act of 1936. It was designed to protect small retail shops against anti-competitive behavior from chain stores. So chain stores were just starting to arise in the 30s, and they would do a bunch of aggressive pricing to drive the small guy out of business. And at the time, everybody shopped on Main Street with a bunch of local shops. You can't grant lower prices to different purchases of commodities like grade or quality where injury to competition may result. Now, that doesn't exclude volume pricing. Exceptions, a larger quantity is purchased, surplus or obsolete, meet the lower price of a competitor. And then here's some corporate law brochures that if you got an interest in any of these things, there's a bunch of stuff there. All right. Passed in 1936, which of the following U.S. laws requires a supplier engaged in interstate commerce to sell the same item to all customers at the same price if the same purchase conditions apply? Any guesses?
C. Robinson-Patman.
Yeah, it's C. So this one is the 1891, the first one. This one's from 1914, and so is that one. And it is, well, that's not the right question. This is it. Yep, C. Yeah. There's 5 questions out there. We'll pick up this stuff tomorrow. So go ahead and work on the questions, and we will go over answers at 2:25 unless you get done early and just raise your hand. All right, let's go over some answers. Find them here. Number 1 is delta. All 4 attributes of fiduciary care are an agent owes. Principal, yeah. All of the above, basically. 2 is also delta. Mendoza is a special agent. He's a salesperson with limited authority. The agency of salespeople is limited to the solicitation of business. 3 is Bravo. DEF is acting as if a contract exists, and if Acme pays the invoice, one will exist. So the Acme engineering manager gave DEF the impression that he was authorized to bind the company contractually, which is apparent authority, but Acme's policies, they do not have actual authority to do so. So Acme must terminate the contract in writing, telling DEF the unauthorized contract signing. 4 is Alpha. Because by performing the service and invoicing for it, ABC companies acted as if a contract were in existence. So they have therefore ratified the contract, even though it was not signed by someone with authority. And 5 is Delta. Lowering prices to meet competition is one of the specific cases in which Robinson-Patman permits price discrimination. All right, any questions? You guys all have a good weekend. We'll pick up with this on Monday.
Thanks, Rick.
Thank you.
Thanks, Rick.
Thank you.